You're breaking.
Yeah. I was not recording. So let me go back to question 4.
Yes.
For purposes of the recording, we have said question 4. The answer is duty of trust and honesty and integrity. Question 4A: did member owe his professional obligation in particular transaction under what circumstances? So duty of trust and honesty and integrity, SOPEC, rule 148 to 156. The other duty is duty to competent and diligent had a client brief, which is SOPEC, rule 54 and 55. Yeah, the other answer is fiduciary duty towards a client and his or her property, SOPEC, rule 80 to 91. So question 2, should Marimingi refer the grievances to advocate disciplinary tribunal? What are the possible outcomes? You discuss question section 64 of the Advocates Act. Yeah, B, C, D, and E. Yeah. So now we are at question 5. Yeah, so those are the answers for question 4 for the purposes of recording. So question 5, you have been assigned legal researcher duties as the High Court in Watamu under the resident Judge Ramini. Judge Ramini is approached in his chambers by Kitomotomo, who has been his friend for over 25 years, seeking advice on legal predicament. Kitomotomo has been charged with a capital offense and presently is out on board awaiting trial. Kitomotomo wishes to know that how the best he can present his defense to avoid conviction. The judge informs you that Kitomotomo peculiar requests and wishes to know whether there are ethical issues that may arise should he assist his friends. Discuss the ethical issues that may arise while making reference to relevant legislative provision and case law, if any. 10 marks. So these are like 10 points. So how do you understand this question, Mr. Wakiaga?
The first one, one of the ethical issues that I would pick out instantly is fidelity to the law and due process. This is where someone is trying to subvert the cause of justice by actually trying to subvert the cause of justice. And another one I would pick is the conflict of interest, where somebody due to friendship they have with the judge, someone intends that the judge would actually bend the rules due to that. And another one I would pick is the outside interest. Yes, because the interest this person has elsewhere outside of his job is actually influencing how he's going to conduct his business in the court. Yes, so those are the ethical issues I think I'm able to pick immediately.
Yes. So this is a question that is testing a student candidate knowledge on code of conduct for judges. Remember, this is resident Judge Ramini has been approached by Kitomotomo, who has been his friend, to advise him. He has been charged with capital offense, presently out of board awaiting trial. Yeah, so the judge asks you what are the ethical issues when he gives advice on to his friend. Yeah, so you discuss the ethical issues that may arise, making reference to relevant legislative provisions and case law. So legislative, when a question tells you about legislative provisions, That is the Constitution, Acts of Parliament, regulations, code of ethical conduct, and case laws. Yeah. So that's how you interpret the question. So, provision number 1. If you are to answer this question, you start with the Constitution. So, any question that comes that is testing you on ethical conduct of a judge, you start with the Constitution. The first point is Article 162(2)(c). The Constitution requires that a judge to be impartial and have high moral character, integrity, and impartiality. That is Article 166(2)(c). Point number 2, Article 75 of the Constitution on conduct of state officer. Remember, a judge is a state officer. What does it say? A state officer shall behave whether in public and official life, in private or in public, in association with other person in a manner that avoids conflict between personal interests and public and official duties, compromising any public or official interest in favor of a personal interest, demeaning the office that the officer holds. So, Article 75 and 166(2)(c) of the Constitution, you start with that. Then you come to the leadership. This is a Leadership and Integrity Act. I want to project it on your screen. Yeah, this is how you the point you use to do your question, the nini. So, Leadership and Integrity Act. What does it say? This was enacted on ethical conduct of state officers.
Are you projecting it?
I want to project it. So, that is Leadership and Integrity Act. It was made to give effect to the Chapter 6 of the Constitution on a leadership of integrity. So, Section 13 is talks on moral and ethical requirement. For purposes of Article 91 and B and 1B of the Constitution, a person shall observe and maintain the following ethical and moral requirements: demonstrate honesty in conduct of public affairs, not engage in activities that amount to an abuse of office. Remember, a judge usually even does not, if he was in a private practice, he usually leave the private practice and resign, because now he's holding a public office. So by him advising his friend, that will be an abuse of office. Yeah. Not engage in wrongful conduct in furtherance of personal benefit. Not. Yeah. So that's some of the points there. If a question comes, not in even to engage in activities, actually and honestly represent information to the public. Yeah, so he's supposed to tell Kimotomoto that he cannot advise him because he's holding a public office. Then Section 16 is on conflict of interest. A state officer or public officer shall not use best efforts. So there is a difference between a state officers. A state officer is a person who holds a constitution office. Public officer is a civil servant. Shall not use the best efforts to avoid being in a situation where personal interest conflict appear to conflict with state office, public officers' official duties. So here is his friend personal interest, which conflict with state officer official duties as a judge. We are together to that point.
Yes, we are together.
So section 13, section 16 on Leadership and Integrity Act. So that is like 4 points. Finally, but not least, now you go to the code of Judicial Service Code of Conduct and Ethics Regulation 2020. Very, very important. I want to nini. I want to project it. Yeah. So I want to share it now. Very, very important. If you are answering a question on ethical conduct, you can see it.
Yes, I can see it.
Yeah, so it is called the Judicial Service Code of Conduct and Ethics. The Judicial Service Code of Conduct and Ethics. This is for judges and judicial officers. So judges have their code of conduct, then judicial officer. Judicial officers are any other person who is not a judge who is working in the judiciary. So if a question comes on magistrate registrars, you apply the regulation. Regulation 34 going, yeah, 34 to 58. For judges is the first one. 34 to 30 to 58. For judicial officers, for judicial staff is 59 to 77. Yeah.
Are you projecting
So
the
it
same?
is
Because I'm seeing a
categorized.
different thing. Are you
Yeah,
projecting the
it is
same?
categorized. Yeah.
Are you projecting the same? Because I'm seeing a different document. I'm seeing from
You can see
150.
what?
I can see written the Kenya Gazette. Then I'm seeing 153, 154, 155.
Okay.
Yes.
Let me save it so that I can you can be on the same line. This is a very common question, so we need to handle it. And now is okay?
Yes, I can see it now.
So judicial service, let me increase the resolution a bit. So the Judicial Service Code of Conduct and Ethics Regulation 2020, yeah?
Yes.
So it is divided, okay, preliminaries, code of conduct and ethics for judges. So when the question is there dealing with the ethical conduct for judges, you look at Regulation 7 until 33. Then if the question is asking you code of conduct and ethics for judicial officers, you look at 34 until 58. So who are judicial officers? Judicial officers are registrars and magistrates.
Okay.
And
Yes.
and the courts and everything. Any person who is doing judicial judicial duties except judges.
Yes.
And if the question is asking you about a judicial staff, these are clerks, secretaries, and all those people.
Yes.
You look at 59 to 77. Yeah. So that is how it is divided.
Yes.
So I have seen in the past they have asked about magistrates. Yeah, they have even asked about cracks. Yeah, so that's how it's divided. But this question now is asking about the judges. This is judge. It's called Judge Lamini. So the first rule, the first point is Rule 7, which talk about independence. A judge shall exercise judicial authority independently.
Yes.
Yeah. So he must not be influenced by personal feelings, prejudice, or biases. Point number 2, Rule 10. What does Rule 10 on private communications? So a judge shall not initiate, permit, or consider private communication related to a matter or a case directed to the judge regarding a pending or impending matter in court. Yeah, remember this person is asking for advice. So the private communications are not permitted, whether the case is before the judge, before the said judge, or another judge. Another rule, Rule 11. Rule 11 is on integrity. So a judge shall discharge official duties, act honorable in a manner that shall not So 11.3. Conduct the judge's personal and extrajudicial activities in such a manner to minimize the risk of conflict with obligation and judicial office. Yeah. So conduct a judge's personal and judicial activities. So 11.3b. Another rule, Rule 16. Rule 16 is on professionalism. A judge should always be professional. So a judge shall carry out the duties is on her office in a manner that assures public confidence in the integrity of the office. Yeah. And last but not least, Rule 20. Conflict of interest. Regulation 20, not rule. Regulation 20. A judge shall use the best of his knowledge. The judge shall use best efforts to avoid being in a situation where personal interest, that is 21, appear to conflict with the judge's official duties. Yeah. Are we together?
Yes, we are together.
So if a question on code of conduct comes in an exams, you start with the Constitution, you go to the Leadership and Integrity Act, then you go to the Judicial Code of Conduct and Ethics Regulation 2020. So this is a question that tested many times in the past. The last time it was tested was in question 3, November 2017. And I have researched it in question year 2008 to 2019 Q&A, page 190. But there, the Judicial Code of Conduct rules were for the 2016. Those now have been repealed by the 2020. But the case law there are relevant. Remember, we have not touched any case law. The question was also asking you to discuss some case law. So you look at the case law there. And this is a very common question. It can come in future. And the related question to this is code of conduct for prosecutors. Yeah. Are we together?
Yes, we are together.
So the last question of the day. So the question that we have dealt with so far today, question 5, question 6, question 4 and 5, those are repeated from past papers. So it is very, very important to look at the past papers, whether through the research question and answers or uploaded videos. Yeah. So the last question of the day. This is question 6, April 2022, which I'm going to read. You have been working as a public relation assistant in your friend's law firm as you are sitting the ATP examination. The firm has recently employed 2 newly admitted advocates. You have been monitoring the activity on both Instagram and Twitter. You have further extended your surveillance in their Facebook accounts and happen to be on the WhatsApp groups which both belong to. You have never commented on any post they have made despite alarming content therein. Recalling your discussion in ATP 105 and 911 guidance on this matter, advise the 2 newly admitted advocates on ethical issues which they must take account wherever they use social media or in practice. Mr. Wakiaga, interpret the question and try to answer it.
The first one, okay, there are 2 issues which I'm actually looking at. The first one is on the confidentiality and the advocate-client privilege, where you can, they say that the information you get, the client information is actually protected by the Evidence Act. Is it Section 134? That you cannot divulge the information you've gotten from your client in the course of your duty without the express authority of the client.
Haya, pause there.
That is one.
No, pause there.
Yes.
I want to correct you. Does the question talk about anything that was shared by the advocate?
You see, one thing, anybody working for an advocate, from the way I understand it, if you are working in an advocate's office and any information that any staff divulges actually binds the advocate. Yes.
You see, let me read the question again, you understand it, eh?
Yes.
So you, Wakiaga, you have been working as a public relation assistant for your friend's law firm as you are sitting the ATP examination. So you are not an advocate. You have been employed in what? Your friend's law firm. The firm have recently employed 2 newly admitted advocates. You have been monitoring the activity on both Instagram and Twitter. You have further extended your surveillance to their Facebook accounts and happen to be WhatsApp group which both reforms. So you, who is working in the friend's law firm, you are not an advocate. These 2 newly admitted advocates, you have been seeing their activity in Instagram, Twitter. Also, you have look at their Facebook accounts and also the WhatsApp group, which you both belong. You have never commented to any post and have made despite alarming content therein. The alarming content is not told which one is they are posted. Recording your discussion in ATP 105 and relying on your relevant guidance on the matter. Advise the 2 newly admitted advocates on the ethical issues which must take account wherever they use social media while in practice.
Yes, another point I was going to was the inappropriate use of social media. That is SOPEC 10. Where we are told that the inappropriate use of social media that undermines the dignity of the profession can actually amount to professional misconduct. Yes. And yes. And the inappropriate use of social media could also lead to the breach of the confidentiality of the client's information. Yes. That is how I wanted to link them. Yes.
So those are like 3 points. So you need 10 points to answer this question.
Another thing I would pick is the professionalism of the 2 newly the two are they advocates? The newly admitted ones. There also lack of professionalism because they are not expected. There is a manner in which the professionals in this particular profession are not expected to behave, especially in the eye of the public, because the standards which have been set for the advocates are much higher than the standards set for the ordinary person in the streets. So lack of professionalism would also amount to professional misconduct. Yes.
Yeah, so those are like 4 points. So this question is testing on the advocates' use of social media. Remember, this question has not told you what the content they have been sharing in Facebook, Twitter, Instagram, WhatsApp group. So you need to discuss the points that are in Code of Conduct 135 to 139. You extract 10 points there as follows, which I'm now projecting the SOPEC. Yeah, that 135. So rule 135. Point number 1, inappropriate use of social media, particularly in a manner that undermines the standing and dignity of the legal profession, amounts to professional misconduct. That is point number 1, which you have already said. So, additionally, materials and content drawn from social media sites may be taken into account by regulatory authority in dealings with the charge of professional misconduct. Point number 2 from Rule 135. Rule number 3. So when someone posts on Rule 136, when someone posts on social media, someone can create or form links with potential clients. judges, and other members of legal profession. This can create informality of the relationship among members of the network, which they potentially undermine detachment and independence of the performance of their work and create potential conflict of interest to arise. Point number 3. So social media 137, rule 137. Social media provide a platform for short, quick messages to be disseminated widely. It is often the case that comments posted online are spontaneous and less guarded. Such comment, if not careful thought out, can damage professional standing of the advocate, particularly when they express unconventional opinions or controversial in nature. That is point number 4. Point number 5. Social media also exposes the advocate's personal and social life online, and this might create an image of advocate which undermine the advocates and more widely legal professional standing in the society. 5. Those are 5. Rule 138. Social media site may be considered or cancel promote oneself and solicit for work. Therefore, care needs to be taken not to breach the rules of professional relating to advertisement. So when you post in social media, you can get solicit for work and not following the advertising rules. That is point number 6. Point number 7, care should be taken to ensure that comments made online are not intended to be relied on for legal advice, as they may create exposure to professional liability claims for negligent and professional advice. So you see, you remember the advocates when they post in Facebook, Twitter, Instagram, they usually put a disclaimer that that is not legal advice.
Yes,
Yeah.
yes.
Point number 7, that is point number 7. Care should be taken to ensure that comments made online are not intended to be read by legal or for legal advice, as might create exposure to professional liability. Point number 8. Social media offers access to wide audience in cost-effective manner, and for this reason, its use has grown dramatically in essence, including by and among professional services. Social media can be used in a way which potentially undermine the standing of legal professional. Point number 8. Therefore, using social media, advocates should be mindful of obligation to uphold dignity and standing of the profession, and should apply same high standards of conduct to online activity they do. That is point number 9 now. At all times, advocates should refrain commenting on current affairs on social media because of confidentiality. So yeah, you have made like 4 points. So someone needs to really look at section rule 135 to 139. It talks on social media. Use of social media, which is related to question 1 that we dealt with. Remember the question on where the client was saying that the social media of the advocate should be used to promote client interest. Remember?
Yes, yes.
Yeah. Question 1E. Yeah. Question 1E. It was Bazeng. Yeah. So that is music can be promoted. So it's related to this question. So we are seeing a repeat of the question. So SOPEC is very, very important when, especially when social media question has come. So someone needs to extract at least 10 points from rule 135 to 139. Yeah. And you shall be safe. We are together?
Yes, we are together.
Sawa. So we have come to the end of April 2022. We have tackled question 4, 5, and 6. Yeah, so the next video, the next class will be on October 2022, part 1, question 1, 2, and 3.